En nombre del ITESO, Universidad Jesuita de Guadalajara, les doy la más cordial bienvenida a nuestro evento, teniendo como invitado al doctor Eckart Brodermann, quien impartirá la conferencia sobre los principios UNIDROIT. Nos acompaña también como moderador el doctor Guillermo Alejandro Gat Corona. A ambos les expresamos una calurosa bienvenida y nuestro más sincero agradecimiento por compartir este espacio con nuestra comunidad universitaria. A continuación, me permito presentar al doctor Guillermo Alejandro Gat Corona, quien más adelante presentará a nuestro invitado. El doctor Guillermo Gat es licenciado en Derecho con mención honorífica por el ITESO, maestro en Derecho Internacional y Comparado por la Universidad de Notre Dame, Campus Londres, donde obtuvo la distinción Summa Cum Laude. Asimismo, es doctor en Derecho con mención honorífica por la Universidad Panamericana, Campus Ciudad de México. El doctor Gat es notario público número 120 de Guadalajara, Jalisco, y es catedrático del ITESO. Ha sido conferencista y profesor invitado en diversas universidades, algunas de ellas la Universidad Panamericana, Campus Aguascalientes y Ciudad de México, la Universidad de La Habana, la Universidad de Ottawa, la Universidad Autónoma de Chihuahua y la Universidad de Guadalajara, entre muchas más. Es miembro de la Barra Mexicana, Colegio de Abogados, Capítulo Jalisco, y de la Academia Jalisciense de Derecho Notarial. Entre algunas de sus publicaciones destacan El Derecho en Guerra Contemporáneo, coeditado por el ITESO y la Universidad Panamericana, y Ley y Religión en México, un enfoque histórico-jurídico. Ha participado como autor y coautor en una decena de libros y ha publicado más de 20 artículos en revistas especializadas. Actualmente es presidente de ITESO AC y un profesor emblemático de nuestra licenciatura en Derecho. Con mucho gusto cedo la palabra al doctor Guillermo Gat.
Thank you very much. We will be directing this lecture in English. I want to thank all of you for being here today. I see many friendly faces of both students and faculty. I also want to thank particularly Salvador Ibarra Álvarez del Castillo, former president of ITESO AC, for being here. Thank you, Chavo, for being here. It's also a pleasure to see several professors. I want to thank particularly Professor Marisol del Rio, Professor Edgar Ayllón, Professor Marcos del Rosario for putting this together. It is very, very nice to see professors like Marcos Cervera, Jorge Huerta Goldman here present. Thank you very much. It is a great honor to be here at ITESO today to introduce Dr. Eckart Brodermann. He will share with us his perspective on various aspects of the UNIDROIT principles, as he elaborates on them in his most recent book in the Spanish language, Principios UNIDROIT sobre los contratos comerciales internacionales, comentario artículo por artículo, which is there lying on the table. This book was translated into Spanish by Christian Sincer Chesnik and Pedro Mendoza Montaño, and it was edited by Tirant Loblanch and the Ilustre y Nacional Colegio de Abogados of Mexico in 2024, 888 pages. If you don't go through it, you can throw it to your boyfriend and it'll cause some serious damage. The first edition in English was published in 2018, and it was followed by the version in Chinese language in 2021. The idea is to finally get it into how many languages? 10. Into 10 different languages. So if anybody knows Hindi, please come and show up with you so that you can start translating. Dr. Brodermann is a Germany-based international lawyer, arbitrator, and professor of law at the University of Hamburg in Germany, specializing in private international law, international commercial contracting, and international litigation and arbitration. He is an LL.M, graduated from Harvard University, They did not expel you from the country at that point. It was still okay. And is a maître en droit by the University of Paris. He is also a senior and founding partner of the law firm Brodermann Jan, Hamburg, founded in 1996, and has served for over 20 years in various roles at the board of the Hamburg Bar, in specialist groups of the German Bar, and as chair of the joint committee of the bars of Hamburg, Schleswig-Holstein, and Mecklenburg, you have to help me out here, Vorpommern, for the admissions of German bar-approved specialists in cross-border business law. Professor Brodermann has written and co-authored multiple books and articles, including this article-by-article commentary on the general principles and rules of international contract law, as compiled and developed by the International Institute for the Unification of Private Law, known as UNIDROIT. That is, the UNIDROIT Principles of International Commercial Law. The most recent version of such principles was issued in 2016. I cannot thank Professor Eckart Brodermann enough for his presence here today. In order to be able to set the concept of the UNIDROIT principles in perspective and consider that the audience here today is formed by a combination of university students, attorneys, and other persons involved in international transactions, I would like to make a few brief remarks of the context in which the UNIDROIT principles are established. As Professor Folsom, if you've never read Professor Folsom, you should. Every city in his examples starts with a B. No other country or city exists. So, as Professor Folsom notes in his book, International Business Transactions in a Nutshell, it is very different for a seller to transfer goods from Brooklyn to a purchaser in Burbank, Baltimore, or Brockton, all of them in the USA, than to transfer them to Brussels, Bangkok, Boca del Rio, or Berlin. Not only do countries differ in their economic and political frameworks, but they may have different currencies, trade rules and restrictions, exchange rates, and various other matters that may make transactions more complex. As Konrad Zweigert and Hein Kötz would put it in their Introduction to Comparative Law, all countries and their legal systems have a unique style and spirit in the way legal solutions are built to concrete problems and opportunities. The problem of dealing with international business transactions and contracting with parties in different countries has created numerous institutions, treaties, and legal instruments of both soft law and hard law that seek either the harmonization or the unification of the applicable law. Some of the most important institutions that have been successful in their attempts to improve the legal framework to enable trust, efficiency, and legal certainty in international business transactions are UNCITRAL, the United Nations Commission for International Trade Law, for example, with the 1980 Vienna Convention for the International Sale of Goods, the CISG, which is perhaps the most frequently quoted example of unification of private international law, the International Chamber of Paris, with their Incoterms, which enhance the harmonization of the law, and of course, UNIDROIT, that is, the International Institute for the Unification of Private Law, established in Rome since 1926 by the League of Nations, with the UNIDROIT principles that Dr. Brodermann shall refer to today. It's very simple. If we start trying to negotiate a contract to sell goods and buy goods into different countries, the reactions of lawyers throughout the world are all the same. Which must be the applicable law? Mine. We were talking about this at lunch, and of course, I used as an example that frequently in a master's degree, I ask my students to come to the blackboard and write applicable law clause. And they all write something like, this contract shall be governed by the laws of Mexico, right? And then when I tell them, okay, now we have a problem. The Mexican vendor of blown glass bottles from Tonalá has not received payment from the purchaser, which is an industry that does cognac in France. What is the applicable law? Well, Mexican law, that's what we set down in the contract. Okay, but what is the Mexican law applicable to that kind of transaction? Well, everybody will say, well, it's commercial law. Of course, it's the Code of Commerce. Oh, the one created by Porfirio Diaz in the 19th century? Well, I'm sorry to tell you that's not the case. When it says Mexican law includes not only codes, but also international agreements in accordance with Article 133 of the Mexican Constitution. When you said Mexican law is the applicable law, you were also referring to treaties, and treaties are superior to federal law. Therefore, the applicable law is the 1980 Vienna Convention for the International Sale of Goods, and only in those matters that are not governed by it can it be governed by the Code of Commerce of Mexico. So on many occasions, what we find is that the person drafting an applicable law clause does not understand the very words that he or she has put in the paper. Some of the founding fathers of the ideal of promoting the harmonization and unification of law as it applies to international commercial transactions are Clive Schmidhoff, René David, and Tudor Bucharest. I can still remember the International Business Transactions course when I was a student during my master's studies at the University of Notre Dame, London campus in 1994. I know, prehistoric. When the first edition of the UNIDROIT principles had just been issued. And my professor, Ewan McKendrick of the University of Oxford, a very close disciple of Clive Schmidhoff, could speak of nothing else practically while he questioned us thoroughly on the entire text of Schmidhoff's export trade. As Dr. Brodermann will show us, a lot has occurred since this first publishing in 1994 with regards to the use of UNIDROIT principles throughout the globe and in a wide spectrum of industries, businesses, arbitrations, and courtrooms. It is very important for attorneys around the globe to be familiar with the content and use of these principles as they are, as Dr. Brodermann establishes in the introduction to his book, a new lex mercatoria, a very efficient soft law tool to be used by the parties in the creation of their contracts and that shall contribute to guarantee the undertaking of transborder commercial transactions, often, as he states, reducing the legal risks of any commercial contract, especially when they are used jointly with an adequate arbitration clause. Dr. Brodermann, thank you for coming to ITESO today. Herzlich willkommen. Thank you very much.
Gracias. Estimada Marisol, I lost my voice yesterday. Estimada Marisol, estimada Guillermo, estimado anfitrión del ITESO de la Universidad Jesuita de Guadalajara. Es un gran placer para mí pronunciar esta conferencia tan espacial y hablar sobre los principios del Instituto Internacional para la Unificación del Derecho Privado, anotar los principios UNIDROIT. Hablaré para los contratos comerciales internacionales, así como sobre el uso de los principios de UNIDROIT para la interpretación y el complemento de la Convención de las Naciones Unidas sobre los contratos de compra-venta internacional de mercadería. Como solo llevo unos 40, 180 días aprendiendo español con Duolingo, continuaré en inglés. Okay, there is perhaps the next button. How do we go on with this? Somebody? You just say next and somebody. I just say next and somebody does. Okay. Okay, before. Can you go back? Great. So here, then let me stay here. So here you see basically the schedule. We will spend the first half with a little bit of basics. How many in the room do real stuff like business? Who is from something else than law? So we have some. So look at them, you know, because that's your future clients, yeah. And all the rest, who of you is doing law? Who of you has ever in her or his life opened the UNIDROIT principles? Okay, so this is why I think let's do some basics first. And then, however, I want to jump, and we heard already some of the basics in your nice introduction, but then I want to jump from the basics then to give you a feeling where the discussion is today, yeah? Because that's moving on. But I promise you one thing, this session, if you haven't done it before, is going to change your life a little bit, because in your practice, when you are out of law school, this will be the future. At least that's my belief. There are other people who challenge that, but I deeply think that is going to be the future, because if, as you said, if you from Mexico contract with me from Germany, why should you accept my law? Even if I plead to you, it's the best law of the world, which is not the case. Only my German colleagues think. Yeah, so no national law is the best case. And mine has very tough stuff on standard terms. It's not the best law for international trade, although most German companies will think it is. But why should I accept your law? I barely read Spanish. You know, how can I know what's in there? How can I know what your courts say on the interpretation of a national law? And if you discuss this with Americans, it becomes extreme, because they say New York law is so easy. Yeah, it may be easy for them. They have LexisNexis, there are all kinds of research tools. But for us, from abroad, it's very difficult to access New York law. I'm still a member. I once took the New York bar. I'm still a lawyer in New York. I'm training a French lawyer, 4 years in Paris. Then I studied at Harvard and became an American lawyer. I took Chinese law. I wrote my master's thesis on Chinese law. And later I studied German law. So I always say I can't take law so serious. My background is private international law. That's a digital key. So those of you who study law, if you have a chance, private international law is really the starting point to get a feeling which law really should apply. That's between the different national laws. And you look at the different questions, and different questions will qualify differently. So if you have a question and you conclude a contract, it starts by, with whom do I do my contract? Who are you? Why do you purport to represent the university? Why should I believe that to you? Either it's trust, because Guillermo is a nice chap and he made a good impression over lunch, so I think I believe him. Or maybe I have shareholders in my back who want my scrutiny, and if later I will just believe I needed some proof, so suddenly I have a point, how do I do that? And these kind of questions, you still need private international law. What we're doing here with the UNIDROIT principles is only the contents of the contract, the core of the contract, but there are other questions around where you need private international law. That's the general setting. So now I turn on my subject, the UNIDROIT principles. Next. So we start with the foundation. Next. And here's already what you described in your nice words. Basically, there are all these different laws, and they're a little bit like sharks in the ocean, yeah? And in the middle, that's you. That's you walking, through all these different laws to navigate through it safely. And there are so many differences in these laws. For example, who can help me in your Mexican code? There is somewhere the principle that your contract should be applied in good faith and fair dealing. You know that principle? Which section is it in your Mexican code? Somebody remembers? Okay, anyhow, it's so deep in your genes, in your basic genes after the first semester of studies, that it's obvious for all of you there is good faith and fair dealing. But if you go to London, not a word with B, but with L, if you go to this London place, they do not have a general principle of good faith and fair dealing. They have something which they call piecemeal solutions, because they think certainty of trade is more important than good faith and fair dealing. So if under UK law, you do a contract and you do not write in a clause that in case of hardship or force majeure, you can adapt something, then you are stuck. And we saw during COVID. During COVID, everything was shattered. And it was tough. I had to once, if under UK law, you have to then argue how you can change something in the contract, you have a very, very bad stand. So this is why it's worth thinking about these shocks. This is just one example. And we could now spend an entire day just on discussing fundamental differences between these different areas of law. I just give you one more example. It's not only the law, it's also, as you already mentioned, Guillermo, the mindset. And the mindset, let's say, of us in the civil law countries in the West, when we think of law, we think of something positive. Law is freedom. Law is shaping it. It's party autonomy. We can do the contract. We can shape the contract. And as a friend, a young professor from China explained to me, one Kun Fan, who wrote a great book on arbitration in China. And she once explained to me, if she hears the word law, she feels differently. She does not feel party autonomy. She thinks of fa. There are about 7 words for law in Chinese. One of them is fa. Fa is roughly like this. It goes from your perspective like this. So this is a verb in the middle. And then on the one hand, you have 3 lines like this. These 3 lines are a symbol for water. On the other side of this sign in the middle, you have a unicorn. You have like it's a picture of a unicorn, a mysterious beast. This mysterious beast can separate good and evil. So in our dreams, we want to be good people every day. In real life, not every business person succeeds being a good person all the time for different reasons. I don't go into that. And so this mysterious beast might push you, and if you don't behave, it might push you in the water. And the verb in the middle means to get rid of. So my friend Kun Fan, when she hears the word law, she feels like being pushed and swimming in the water, always fearing that she might end up in the water. And that comes from hundreds of years of suppression, first from monarchs and later from the Communist Party. And in that combination, there is a different feeling about the contract and the law. So that is the reason. It took me quite a while to find that out, but I discussed with many Chinese friends that they all concur with me. If you once you conclude a contract from an American or also Mexican perspective, you think that you have organized the obligations and that you have now, you just have to do it, what you do in the contract. The Chinese say, the moment I've now signed a contract, I know from now on I can trust you. Now I can help tell you my truth. And now we really start the negotiation. So it's a totally different mindset, and that is bound to lead to difficulties. This is why it's good to have something neutral there. So much just to give you an idea to what extent there are these sharks out there. There's this danger of falling into the water. Next, please. Then comes another point. So we found, in the last slide, the objective need that we need something neutral, something underlying. And now comes the point that even my own law may not be the best law, and here's why. Because national legislators, they look for the national needs, the national voters. And this is why they're made for domestic purposes. That's what they mainly have in mind. Next. Okay, then on top you have language barriers. If you and I, we write a contract, and we write this in English, I don't want a native English speaker sit as a judge in New York or London or arbitrator and read through it. He will interpret stuff in our writing which we didn't both not mean, because we don't speak English. We try our best, but we don't speak English like a native. And there are these cultural barriers. I just gave this example with the Chinese. Next. So as a result of that, you have all these red flashes, examples of risks. Yeah, you have different deadlines. You have different feeling about time. Yeah, in the Arabic world, time has just a different connotation. That's why they're a little bit against charging interest, find other ways to do it. There is different public holidays. Yeah, if you have a long project, it is very often that you end up in problems because one has a holiday, the other hasn't. So I think I don't have to go through all this. It just gives you a feeling. And of course, it costs money to dig into the law of the other country. What does your Mexican law really say? Yeah, to find all that out. And even AI will not help, because AI will give you a very quick feeling of things, but in the end, you have to make the assessment. And to do that, you cannot do it. You need colleagues, and that's more costs, and you need more legal team. Okay, and then there are time zone differences. Let's go to the next. So that's my favorite slide, which I prepared for you, which is new. That's the ingredients. That is, to overcome that, we had this effort started indeed from the famous lawyers, which you mentioned, and based on an initiative from 1968. So basically, mankind invested close to 5 decades to write these principles. I had the privilege of being part of the working group as an official observer from 2004 to 2012. So I have a little bit of feeling for some years, not all the time, not 50 years. I'm not that old. I am that old, but not that all that there. Anyhow, how we worked and how it worked. And in 1994, when you had your lecture, they were already great and aspirational. But today, they have arrived there. There are general principles of law. And it starts with the wording. For example, they say, estos principios establecen reglas generales aplicables a los contratos mercantiles internacionales. Estos principios pueden aplicarse cuando las partes hayan acordado que su contrato se rija por principios generales del derecho, la lex mercatoria o expresiones semejantes. That means already in the wording of the preamble, they had in mind when drafting, we have to draft something which is so universal that it is acceptable everywhere, in China, in New York, in Mexico, in Germany, everywhere. So we have the wording. Then we have the purpose. I just gave you this one example in paragraph 3, and in the same way, they said in Article 4 of the preamble, estos principios pueden aplicarse cuando las partes no han excluido el derecho aplicable al contrato. So they foresaw the possibility that the parties have not said anything. Of course, you have to see the context. And when you study private international law, you will see it's not always that easy to just apply whatever you like. But if you have the right setting in arbitration, that's special procedural things, in the right setting of an international arbitration, you can have that freedom and determine. I spent, a couple of years ago, I spent 3 months, actually 2 years, but 3 years, 3 months was a core. I worked as an expert for an international arbitration tribunal in a big thing which ended up in an award of $15 billion against the state of Malaysia. And the question to me was, can you apply the UNIDROIT principles as general principles of law? The tribunal had decided they wanted to apply the general principles of law, and now the question was, 15 billion was huge stuff. Yeah, not that often, these kind of cases. It was an interpretation of a contract of 1868. It was somewhere in Asia. At that time, it was dominated by Spain, so in the end, we had an arbitration in Spain. Details too complex for here, for the moment, but it gives you a feeling that these kind of situations do happen. So the wording and purpose, so that's already very aspirational. And then you have, of course, this history of comparative legal research and compromise. So they really looked at all the relevant legal orders, especially at the more recent codifications, like the Canadian codification, for example. And they discussed. And basically, they went through the life of a contract, from contract formation to prescription period. All the questions which you have during the life of a contract. And in the end, over those 4 editions, they ended up in 211 rules. And for each rule, and this is why it took so long, we sometimes discussed 2, 3, 4 years with the rapporteur preparing, presenting to the working group, and when there was no consensus or no clear vote, then he would be sent back and had to do more homework and research and would come back a year later. And so, and for each of these 211 rules, the rule had to be drafted in such a way that it was specific enough to meet the English need for certainty, because there were also English lawyers, like Roy Good, for example, in the room, or else you had to make sure that the rule also met our standard of good faith and fair dealing. So for each little detailed point, they found the compromise. So this is why it's universal contents. Since 20 years, I'm working with the UNIDROIT principles, and ever since I'm teaching this subject, and I have students from abroad, I always give them the homework. Please compare your own law and the UNIDROIT principles and make me a summary of that. And it's fascinating. Each time the result is they are quite familiar to what is in our own law. And you get the same answer from the Chinese, from the English people, from everybody. Because once you start digging deep, you understand that it's the case. The other day I had an arbitration dispute with English lawyers under English law. And I turned it, I switched it the other way around, and I told the English lawyers it was a little bit difficult, and told them, listen, why don't you take one of your young associates and have her search, or have him search, for this rule? There must have been somebody in England, some judge, who has said this. And then I quoted one of my principles, because I know that each of the principles has endorsed also English case courts. In the beginning, he looked like me, like if I'm crazy, but 48 hours later, he changed his mind and had found a case. And so you can use it in all directions. So from a New York perspective, Chinese perspective, German perspective, whatever you take, it is okay, it's universally compatible. And that alone is big. A word maybe on your Mexican law, what we had at lunch. When you study your Mexican law, you study, and your civil commercial code, you study like a house. It's like an architecture. An architecture learns how to build a house, but the architect knows that many kinds of houses, they all have a door and a roof and maybe a window, but it's still houses. In the same way, in your Mexican code, like my German code, it's just one house for civil contracting. And then we learned that you have even 2 houses in Mexico, because Mexico, like over 90 other countries, are party to the Convention on the International Sale of Goods, the so-called CISG. Is there any moot court students in the room? No. Moot court, there is a Wies moot court which always applies these rules. So there is a CISG. So over 90 countries have the identical international law. What's the difference of international sales? Sales law in Rio, New York, Tokyo, Mexico or Berlin, the answer, there is no difference. It's the same. And that is really quite something to take home from today. So in Mexico, you already have two houses, your own house, the national house, and the international house for contracting. And with that said, these blue bubbles there, we have now various areas of application. And I put the paragraphs below, so you can use them like stated in para 1 of the preamble as general principles for contracting. You can use it to interpret national law. There's over 35 countries where top courts of the national countries have said, we interpret our own law with using the UNIDROIT principles. Alone in Spain, there are allegedly over 700 court decisions of that kind. From the sources, I've seen over 100. The rest is hearsay for me, but they must be out there. And you can also use it, we'll discuss it at the end of this lecture, to interpret international instruments like the CISG. And you can use it for dispute resolution, in arbitration, or for pleadings to judges. And also you can use it as legislators. So that's quite many kinds of ways in which you can use them by courts or by arbitrators. Next, please. So I would like to give you that picture. Next slide, please. Sorry for my voice. So that's the UNIDROIT principles.
Someone singing with mariachi yesterday, that's why.
Oh. So that's the UNIDROIT principles. They're like a chameleon. They really serve many purposes because indeed many legislators have used them. Let's take the next slide. So you have something which may sound familiar when you've ever looked at the source of customary law. You know, you have treaties, you have customary law, you have national written law. It's practice. And the question, have they been received in the relevant legal community? We call it opinio juris. And that, if those two elements are there, you can speak of general principles of law. Let's see what is out there. Next. So, practice. Next. This is just some of the countries which have used the UNIDROIT principles as a reference when they revised their law, most recently, for example, France in 2016, but also the German legislature in 2002. So it's not all the countries on there, it's just some of them. It would be the Mexican legislator, I don't find there because the Mexican legislator, I don't think they've used it, frankly. Yeah. No, I think I'm quite sure that they have not used it yet. But every legislator who does today a revision of its own contract law, I don't know when did you have your last reform of your own contract law? Not in the last 20 years. I would have noticed. I discussed so much with Mexican lawyers about this. Christian would have told me if there had been an adaptation when we discussed this. So that's quite impressive of many continents. Of course, to different degrees. They didn't copy the entire UNIDROIT principles, but some, for example, Lithuania, they have, in many of the East European countries, they have copied entire sections on damages into their own law. Next, please. Oh, that's helpful. So here I give you, they have been used by national courts. I just brought you 3 examples, and there are hundreds. Next. For example, this is Israel before it got crazy, 2014. And national courts have at times made use of the principles as equal in value to research literature. They take it like a source of interpretation. But sometimes courts use them as a breaker of balance, as a final word to make a decision between different opinions expressed in the literature. So if you can interpret your law in one direction or the other, and one of the interpretations is in line with the UNIDROIT principles, then you can argue that this interpretation is in the modern spirit of integration and interaction between the different nations. And that my argument has been discussed in that sense also in England, in Australia, in New Zealand. Next, please. And I've spoken with that judge, one of the judges who made that. This is Italy. I deliberately take an example of one of these old traditional laws like Italy, Germany, France, who all say we are the oldest laws in the world since Napoleon. But even they relate to it. And there is a principle, this principle Article 1.8, an expression of good faith and fair dealing. And perhaps you can help me and read 1.8 to them.
Artículo 1.8 de los Principios UNIDROIT. Título: Comportamiento contradictorio. Venire contra factum proprium. Una parte no puede actuar en contradicción a un entendimiento que ella ha suscitado en su contraparte, y conforme al cual esta última ha actuado razonablemente en consecuencia y en su desventaja.
So that's a quite straightforward principle, and the Italian court interprets its own Italian law and now refers to Article 1.8, so indicating that it's in line with international inspiration. Of course, you can discuss from a critical perspective, is this only an ornament or is it basing it on it? But that's assessment. The fact is Article 1.8 is mentioned in these judgments, and in many judgments that alone is, has a value. Let's go take the next. That's a judgment of 2020, so quite recent. So that's the modern trend here. This is one from Paraguay, and I like the sentence. We cannot fail to mention the UNIDROIT principles, to which we resort as an interpretive tool to complement our internal law. The highest court in Paraguay says they use the UNIDROIT principles to complement their own law. And I think it was in Colombia or Venezuela, Colombia, there was even the Constitutional Court applied the UNIDROIT principles. There was a change in the law. It was attacked as unconstitutional, and the Constitutional Court found that the new law was in line with the UNIDROIT principles and said, so it's not against the Constitution if it's the common understanding around the globe.
We had the chairman of the Colombian, was it Marcos, the Colombian Constitutional Court chairman that was here, Presidente de la Corte, yes. He was here a couple of months ago.
Great. So next. So now we have practice. I could go on the practice. In my expert opinion, went on for, I don't know, over 100 pages on practice examples. And now we come to opinion juris. Is it also received and accepted? So in the end, you need this complex law needs to be simple. So there's practice, and now there's opinion juris. Next slide, please. So opinion juris, I thought it's a good idea to start with the United Nations. UNCITRAL is the very commission which was in charge of the CISG. So they know something about international contracting. And they have said 3 times, 3 resolutions, 2007, 2012, 2021, so very recent. Overall, general support was expressed for recognizing that the UNIDROIT Principles 2016 set forth a comprehensive set of rules for international commercial contracts, complementing a number of international trade law instruments, including the United Nations Sales Convention. They even say it, complementing the United Nations Sales Convention. That was for our lunch discussion. It even says explicitly in the UN resolution. Congratulating UNIDROIT on having made a further contribution to the facilitation of international trade by preparing general rules for international commercial contracts. And here the quote goes on, it's missing on that slide. The next words after the point here is commence to use the UNIDROIT principles. So 3 times they made it that way. Next slide, please. On my computer, I have a newer version. This is the last words which missed here. And then, in addition to United Nations, we also have international organizations like the UIA, which is at the origin of this conference. I understand that this conference is the start of a new development of the UIA, which wants to go more into universities. And this declaration, I had the honor to prepare first draft, but it was a native American, actually a friend from law school. I went to law school like you, and then your classmate at one time has a position where he or she can help. And he looked at it, and he liked it, and it went then through all the commissions. So in the end, the UIA decided to increase the option available to member UIA and the international legal community in advising clients with respect to international contracts. And because the UNIDROIT Principles 2016 provide one effective, efficient option for drafting and interpretation of such contracts and for application in the resolution of disputes relating to such contracts, UIA hereby recommends that the UNIDROIT Principles 2016 be considered by its members and by the international community as an important option in connection with drafting, interpretation, and resolution of disputes relating to international contracts. And today, the UIA is meeting again, and after 5 years, they are revigorating and reshaping that resolutions and updating it. So there is some really international consent. Next slide. Then only this month, I introduced UNIDROIT to Asia. That's an international organization, also big, for young lawyers below 45. So I know from your age, 40 is old, but from my age, below 45 is young. So enjoy that you have in front of you at least 20 more years of being young. And basically the same language. They recommended it also. Next slide. And this is South Africa, just to give you another feeling for another part of the world. And there they say, for example, here at number 2, if parties chose the general principle of law, the lex mercatoria, international commercial law, or the like, govern their contract, the following instruments may be applied where relevant. The UNIDROIT principles, they explicitly allow that. There is another judgment which comes to mind from Brazil, Rio Corte to Brazil 2017. They say it's a new lex mercatoria. So we have many, many, many quotes which go in that direction. Let's take the next slide. Klaus-Peter Berger, that's a German guy, was a very forefront, who was also at some point with me in the working group. And he writes in 2024 in a very famous international arbitration journal, there's growing acceptance of the UPIC, that's the abbreviation, as an independent legal system of transnational contract law, and not just as a restatement like reservoir of individual principles and rules. So as a whole, that's a big discussion which we have in academics. Do we have to accept the UNIDROIT principles as a whole? My answer is yes. Counter opinion, it's piecemeal solutions. Yeah, and that's the point. In 1994, it was all aspirational, and 30 years later, we have practice, and I call it emerging opinion euros, so that nobody can over-criticize me. Next, please. So that was basis. Is there somebody having a question on the basics? Now, by now, you have probably understood, why they are there, okay? And they're there because they are neutral, well thought through, university compatible, etc. Sorry for my voice, it must sound awful, I'm so sorry. So, now is something which I invented together with colleagues from around the globe. I basically shared people like I'm now doing for my World Congress next year. And then we had a little debate, and the casting vote went to Evans Levitt in America. Evans Levitt was at that point in-house counsel of a Fortune 500 company, one of these huge companies. American company owned by Japanese, biggest shareholder in the end is the Tokyo stock market. And this American company owns all kind of about 18 or 20 European companies and others, over 350 companies around the globe. And they just had bought three new companies in Germany. When I met him at a conference, he saw my book. That was on a Friday. On a Monday, I got hired and helped him to integrate the companies. And we had somewhere in Texas a breakfast coffee. And then he said, and we later discovered he is Harvard one year before me. So we had this classmate stuff, which helps. You know, it helps if you look right and left and know your students, know your classmates. Networking, and you can start it right there where you know. And he then said, nobody likes the convention, meaning the CISG, so let's not do the uphill battle, let's go for the new stuff. And basically because he trusted me, because we had this relationship since law school, that he entrusted me that I could use them. And I fell into the UNIDROIT principles first in the year 2000 in an arbitration in Switzerland. We were both lying, more or less. Of course, we always say the truth, but we were arguing English law should apply because English law is so neutral. But my client came from the Caribbean, and then, you know, there is still some relationship to England, so England is not that neutral. And the other side was no better. They came from Turkey, it was a Turkish state, and they argued Swiss law should apply, which is so neutral, which of course is also not the case, because if you know a little bit of comparative law, you know that Turkish law is a translation of Swiss law. So, and we had a great arbitrator, and he said, why don't you try the new thing? The new kid on the block, and we looked into it with 48 hours to decide, and we found that from whatever perspective, that was good. And we were claiming lots of damages, millions, and the other side was denying damages. And from our attacking side, we said, listen, if the other party has broken the contract because they have breached confidentiality, they have told the price relevant to somebody else. If they have done that, we get damages, but we will never get unlimited damages. In all the systems of the world, you have some limitation. And whether you call it, is the question foreseeable? That's like the French approach. Is it too remote? That's the English approach. In Huxley with Huxendale, 1854. Or is it German approach, adequate, the relationship? Does it really matter how you call it? No. In the end, you need to convince the arbitrator, and there needs to be some nexus. So we could just as well work with the UNIDROIT principles than with English law. So out of that, casting vote was Evans Levitt. We call it simplified global contracting. Next. And that is, we combine an arbitration clause plus a UNIDROIT principles clause. In this lecture, we concentrate here on step 2. Step 1 is a lecture by itself, and just as one word, for those who don't do this every day for breakfast, when you go to court in Mexico, because you say, like in your example, we take Mexican law and Mexican courts, it doesn't help because the guy on the other side in Berlin, he may not accept the judgment. Your judgment from Mexico goes until the Mexican border. And to get it across the judgment, you need international treaty. And the best treaty in that regard is the International New York Convention on Arbitration. Of course, for the specialists here, there is a new treaty also on judgments, which Mexico has signed. But that's another topic.
I'm sorry to interrupt, but I think this is a very important subject. I think this also links with the amendment to the Mexican Constitution last year regarding the judicial power. Many of us, many do, but many of us do not like the modification to the Constitution. Maybe many of us have less confidence in courts based on this amendment. And one of the big advantages of arbitration is precisely that you do not have to rely on those courts, but rather on neutral specialist arbitrators. I think that we should work together at ITESO, Marcos, with Jorge Huerta, who's the expert in arbitration here at ITESO, so that we can develop more and more a natural approach by all of our students to arbitration. It should come natural. It shouldn't be the interesting exception. It should be a natural approach, not only to international business transactions, which is basically what Dr. Brodermann is referring to, but day to day, so that El Señor Barriga can collect rent from Don Ramon. It can be something as simple as that, and an arbitrator could be well worth it. But in this case, of course, in order to be able to execute the award granted by a judge, it's much, much simpler if it's an arbitral award. So I think there's a lot of work, and especially for you guys, based on the new conditions, I think worse conditions than they were 20 years ago. But that's the reality, and we have to work around it, and we have to work in Mexico to rebuild trust in our judges, which we have lost based on the amendments to the Constitution in 2024. Sorry about that.
When I said in my plane coming here, next to me was Mexican businessman, and I don't remember names, but he's probably famous, or at least his company is famous, and you will all know it. And it's a famous Mexican company. And as a result of your justice reform, he told me the story how he has transferred the seat with all the trademarks to Luxembourg, to Europe, instead of Mexico, combined with arbitration, and so that he has, it's asset protection for him, that he's not dependent on national judgments. But I'm the foreigner. I'm not going to criticize your point. I'm just, I'm a deep believer in freedom and independence. And I have heard many Mexicans, like yourself a moment ago, shading doubts there. So arbitration is something important. And if you combine arbitration with the UNIDROIT principles for international contracts, that's what I call simplified global contracting. And I would like to make that a movement around the globe. Next. So again, next. Now it visualizes this nice idea. Next. And one more. Now we have it. Simplified global contracting. So next. And basically these UNIDROIT principles are what we already heard. It's party autonomy, which includes, by the way, the freedom to change individual principles. So if you're a very nerdy person from whatever jurisdiction, at that point, not all, but some Englishmen come to mind who like certain principles, not, there's one principle in case of hardship. You can discuss if we have to adapt the contract because of COVID, for example, do we leave the last word to the judge? And during COVID, I very often put the relevant clause from the UNIDROIT principles on the wall, negotiate with the people and say, that's the proposal, but we are free with party autonomy. Do we want that end? And I've had all answers. I've had situations where we agreed, okay, that's good, leave it as it is. I've had other situations we said, no, we don't want the judge to decide. And then we change it and say the last word is left to agreement. But if you leave something to agreement, in the end, you end up in arbitration. I mean, we can agree to agree, but it's sometimes very hard. In the automotive industry, I know examples where for 5, 10, 7, 11, and even 20 years, people have not agreed, and then they still live with this old contract. So that's difficult situation sometimes. So party autonomy is there. Good faith and fair dealing, you already heard some examples, like the 1.8 example you helped me reading. And it's fair business practice through all these 211 rules. Next. No, not next. Yeah, next. So, I already mentioned it. All these points are in there. And one very point, from formation, validity, performance, non-performance, set of limitation periods, assignment. Interpretation. Interpretation starts with language. Now we have again our problem that I don't speak Spanish properly and you don't speak German properly. And how do we interpret our pitch in English? Yeah. And on interpretation, in Mexican law and German law, it's important that we find out what is the real meaning of the minds, what the real intention of the parties. And the English, I told you, they just look at the plain meaning of the word. In New York too, just what is the plain meaning of the word? So it's a very objective approach. And UNIDROIT combined it. 4.1 or 2, number 1 says you look at the real intention of the parties. And if you cannot establish it, then you come to number 2. And I think that's so important that I would ask you to also read this one.
Artículo 4.2 de los Principios UNIDROIT. Interpretación de declaraciones y otros actos. Las declaraciones y otros actos de una parte se Perdón, 4.1. Intención de las partes. El contrato debe interpretarse conforme a la intención común de las partes. Si dicha intención no puede establecerse, el contrato se interpretará conforme al significado que le habrían dado en circunstancias similares personas razonables de la misma condición que las partes.
Okay, so it's a great combination of the two things that you can combine the two worlds. Next, please. And this is what I already mentioned. 1.7 is what we heard on good faith. But the reality is you have so many concrete applications of the meaning of good faith, and you know the rule that the more specific has priority over the general. So if you really read, few people take the time to read, if you read the UNIDROIT principles, you rarely need 1.7. The textbook example where you still need 1.7, if the seller delivers to you the good at 2 a.m. in the morning, you're not obliged to open the door at 2 a.m. in the morning. You're allowed to sleep. That's general principle of good faith for dealing, that in our businesses, you don't have to open the door at that time. And for that, you can rely at 1.7 because they didn't make a specific rule on that one. But otherwise, everything else, like 1.8, we had that example, is written in there. Next, please. So, and if you combine it with an arbitration clause, we discussed that briefly, you can have competent international arbitrators who are a little bit familiar with this kind of international things. And of course, if you make an arbitration clause on the rent, don't take the international arbitrator, take somebody who speaks Mexican and has a feeling of good sense here. And it has all the advantages of arbitration. You can determine the language, you can determine the cost, you can determine the seat. I've seen both concepts. Do you want a place which is easy to reach by plane? Or do you want a place which is a little bit more difficult to reach, but once the people are there, they're really concentrating? Yeah? Next. And in that context of an arbitration clause, now I go back on one level, it's not long anymore, but I go now on the next level, private international law. You have sometimes different rules of private international law for the courts and for arbitration tribunals. And here we look at the ones for arbitration tribunals in my example, because that's my ideal world. And here you have a reduction of the mandatory rules, but that, I don't go in that depth now, but just to kind of hint, when you go deeper into that, on that level you have less of these mandatory rules, because which sanctions, for example, to be applied, the arbitrator will look at the jurisdictions where the tribunal, where the award is likely to be enforced. That's a little bit different than sitting somewhere. With these days, these Trump days, sometimes it's easier to relate to that system than to be stuck to the Court of New York. Next. So there are basically 4 ways to use the UNIDROIT principles in an arbitration procedure in National 1. You can choose them. You can use them as general principles of law, as a tool to interpret, or as a tool to supplement uniform instrument. Next. For each one, I think there's a slide. Next. So, this is psychology. Law is in the end always psychology. It's fiction. Law is fiction. It's fiction on which we agree as society. So, if we understand that we speak with other people, I speak with you as a human being, I want you to understand. So I must congratulate this university. I've never seen this effort of combining business and law together and inviting them together. And that makes so much sense. But in the real classes, most students do not take a class on private international law. There are many other important subjects, AI, IT, IP, Constitution, there's so many important subjects. But if you want to act internationally, and I think we have no choice, we need to act internationally, we also have to look at this. But the reality is different. Most students, I would estimate, around the globe, 95% of the students do not see the international stuff. It's maybe 5% who really see it. So the probability when you use a choice of the UNIDROIT principles clause is that your opposing counsel on the other side does not know the UNIDROIT principles. This is why I reworded that clause to make it itself understandable. Something along the lines that the contract shall be governed by, and then now I describe it, general principles and rules of international commercial contract. That is something one can understand even if you don't know what is UNIDROIT. As compiled and developed by and then I explain, International Institute for the Unification of Private Law. And only then I mention UNIDROIT. So the reader does not feel offended by not knowing. Imagine you want to contract with me, and you hear for the first time of that thing. You don't want to get the feeling that I'm overrunning you. So this is a psychological way of drafting that clause. And then I go on, I assume that people don't know what this institute is. So I say initially set up as an auxiliary organ by the League of Nations. So, it's just not any private club, it's really something high up. And then comes the long name of the UNIDROIT principles. Then the next point I leave away if I negotiate with English people, otherwise I put it in, or with Singaporean people, which are based on the overarching principle of good faith and fair dealing. Every American is on board at that point because they also have the principle of good faith and fair dealing. Sorry to say that, except for the president. They shall apply as default rules for those issues which are not specifically regulated otherwise in this contract. And as default rules, thereby that's written for the Americans, you have the choice to do things otherwise, party autonomy, if your clients want it otherwise. Next, please. So, and here I quoted for you the rules of arbitration of the Center of Mexico. And if you look here at Article 23, it says, the parties shall be free to agree upon the rules of law to be applied. And that's a big point. The UNIDROIT principles are soft law, there are rules of law, there are no state law, and your arbitration law explicitly gives a hard law basis to apply soft law, because it says you can choose rules of law. And that's freedom, and that's good stuff which your legislator did here. In the absence of such agreement, the arbitral tribunal shall apply the rules of law again that it determines to be appropriate. So, next. Then, of course, there are also general principles of law. And this, for example, is a quote from the arbitration tribunal where I was the expert against Malaysia. It has become public because it's state-related, so I'm not breaching confidentiality here by showing this to you. You find this on the internet. The UNIDROIT principles, writes the arbitration tribunal, reflects the character of generally accepted principles and rules of international commercial law. The arbitrator declares that he should apply general principles of international law to the merits of the dispute and specifically the principles of international commercial contracts endorsed by the International Institute for the Unification of Private Law, amended in 2016 to wit the UNIDROIT principles. So that's quoted from a real arbitration sentence. Next. And also 2020, so we really have modern stuff here. And now I come to that was the end of simplified global contracting. Is there any question on that? No? Up for a last little one? Still awake? Then next. Okay, that's ample. So, there is this convention on the international sale of goods. As we learned, the other law of contracts which you have in Mexico, especially for international. And this treaty says whenever there are parties from two countries which are subject to the CSG, then you end up in the CSG. And now comes the question, CSG was negotiated by the United Nations in the 1970s. That's even old for us. Yeah? Yeah, great. So, and how do you interpret the CSG? How do you live with a treaty which is 50 years old? And so what happened is in Switzerland, a Swiss delegation proposed to UNIDROIT in the 2000s, in this century, to change and to make a new convention overarching. But writing a convention takes years. And many states like America said, no, we don't want the money, the time, the effort, we're not interested. So that's the situation. And now we come to the point, how do you interpret and how do you develop the CSG? And this is the text of the convention. Because of my voice, would you mind reading Article 7.1 CSG?
Of course. Article 7 of the 1980 Vienna Convention for the International Sale of Goods. Number 1, in the interpretation of this convention, regard is to be held to its international character and to the need to promote uniformity in its application and the observance of good faith in international trade. 2, questions concerning matters governed by this convention, which are not expressly settled in, are to be settled in conformity with the general principles on which it is based, or in the absence of such principles, in conformity with the law applicable by virtue of the rules of private international law.
So you have internationality as a goal for interpretation. It needs to be international, uniform, in good faith. That's para 1. Para 2, resort to private international law and national law is the last resort. You should first look, is there a principle on which whatever rule in the CSG is written is based. And now next, please. And here comes the point. UNCITRAL had no chance to adapt it, and there may be some rules which need adaptation. We have electronic commerce, which we didn't have in 1980 when it was done. There's some development in our life. We have internet, all this stuff. And so, and of course you can say the UNIDROIT principles are from 1994 or 2016. How can they express things on which a convention of 1980 is based? In the first moment, you have a logical rub in your mind. And now these, and I help you now to overcome this rub. It's normal to have it. It was also my first instinct, but here comes the argument. The 3 organizations joined forces, United Nations Convention on International on the United Nations Commission on International Trade, that was UNIDROIT, reached out to the Hague Conference, that's an international organization in Hague, which has done lots of treaties, and UNIDROIT. And they jointly wrote this legal guide to uniform instruments in the area of international commercial contracts with a focus on sales. Because 3 parties made it, it's called the Tripartite Legal Guide. And now next. Next slide. And this legal guide has 126 pages and some very important sentences in there. There are about 5 relevant ones. And the most important one, I would again ask your assistants, can you read that? Because that's important.
Whether and to what extent external principles
126 pages.
may play a role in filling gaps in the CISG in the absence of an agreement of the parties is an open issue. In the case of the relationship between the CISG and the UPICC, the common understanding is that the UPICC are not, as such, considered to be the general principles of the CISG, but rather as being able to serve to corroborate the existence of a given general principle, and thus they can be a tool to interpret the CISG, or to fill its gaps wherever there is no conflict between the 2 instruments.
And that's really great stuff, because the 3 organizations jointly say they overcome our logical rub with the years and say you can use it. Because what we did in the working group, we always started with the CISG and looked, and for apart from 2 or 3 small exceptions, usually the idea of the CISG was sometimes verbatim copied because it was already good and settled, and very often we developed it further in more detail. For example, the Article 4.1, which we just heard on contracts, and 4.2 is the same on unilateral declarations on interpretation. That's a level of detail. You don't find that type of rule in the CISG. The CISG in the 70s was very specific. It has a history. The history is that UNIDROIT developed a sales law. In 1964, in The Hague, one agreed on a sales law. In the end of the 1960s, we had a lot of new states coming up and emerging. A lot of the colonialism stopped. Lots of European nations went away from Africa. A lot of new African states emerged. And basically, all the new states on the block said, your convention, your sales law is a little bit too seller-friendly. Usually you are the seller and we are the buyer. At that time, that was the case. Now it has changed. China is now more seller than something else, etc. So, other story. So this is, with that background, they revised and made the CSG. So they had a different focus than we would have today. And this is why it's very helpful that they now got together. And basically, next slide. Basically, they now said, CSG, are you sure that there's no slide in the middle? Can you once go back? Okay, then the next slide, it's okay. The slide which is missing for me is CISG plus UNIDROIT principles equal one system. It suddenly becomes one, and that's a big change of paradigm. Very recently happened in 2021, and the community is just realizing it now. This is why the UIA made this update this morning, if they did it. I know it was on the agenda for this morning. And here is now how you can do it. The 3 kinds. Sometimes it's based on the CSG and further developed. If that is the case, then you can argue with that. For example, if you sell a product, then and it needs to get through customs, you need certain documents. So there's an obligation somewhere in the CSG that the buyer or the seller has to give certain information or the buyer has to give certain information to the seller so that it can go through customs. That's a very specific obligation of cooperation. You have 3 of that kind of very specific obligations. Out of those 3 specific obligations, you can deduce that intrinsically, so out of the convention, you can deduce that there's a general obligation of cooperation. That is logical law. You can do it that way. But for a practitioner, it makes it much easier if you don't have to argue a long way to come to a duty of cooperation. If you just open the UNIDROIT principles, as the last one we look at, 513, it says it in so nice words and so easy. So this is simple to read, to understand for everybody. You don't need to study, especially 513, please.
Artículo 5.1.3, cooperación entre las partes. Cada una de las partes debe cooperar con la otra cuando dicha cooperación pueda ser razonablemente esperada para el cumplimiento de las obligaciones de esta última.
So this makes it really beautiful. So then there's some issues which are not covered, like plurality of obligors or limitation periods. So there's some things which are just helpful if you add them. And there's some red lights, the very rare rules. For example, the dispatch principle, it's one of the 3 exceptions. In the CSG, they said it was, remember, mine said seller-friendly. If I send away the letter, it's deemed to be arrived, so it's a dispatch principle, so it's very, very easy for me as seller. And the UNIDROIT principles say, I have to make sure that it arrives with you. And so there's very few points, and if, of course, the UNIDROIT principles deviate, they certainly do not restate something on which the CSG is based. But it's a system now, and it's an easy system to work with. Next, please. Yeah, here's some examples. Interpretation, we heard it, no form required, non-performance defines place of performance. We don't go in these details, but with that, if you look at the slides, you can discover that yourself. Now, once you have the concept, in law, you always just need the scheme, and then you can play yourself detective and take it from there and develop your argument. Next. The new stuff, which is not at all in the CSG. Conditions, yes, also doesn't exist in the CSG. Because, of course, UNIDROIT principles, that's important. UNIDROIT principles is more than just the sale of goods. It is general contracts. You can also use it for joint venture contracts, for merger and acquisition contracts. It was used last in October, November 23. It was used for a $61 billion transaction between China and America, plus 8 million deaths, so a $69 billion transaction. And why was it used? Because we have businessmen here and lawyers. I went to a friend from Harvard who is a businessman and asked him, can you read my book before it goes to print? I want that my book becomes readable for normal people and not only for the lawyers. And he read it on the plane to Hong Kong and came back and wrote me an email and said, I'm impressed by the level of detail of these rules. In all the contracts which I can influence, I will put them in. And I forgot about this conversation. 5 years later, I was in Rome. Next day, I had to give a speech, official speech, 30 years of UNIDROIT principles. I had a voice and good humor, but this dialogue came back to me, and I rang him. I got him on the phone and said, listen, Bill, at the time you said you would do something. Did you ever do that? And then he told me about this trick, about this $69 billion transaction, and allowed me to share it and to write about it. And there were Chinese lawyers and American lawyers. And the American lawyers, of course, said New York law. And the Chinese said, no, but $69 billion we are going to pay. We don't pay according to New York law, Chinese law. So we had exactly that conflict, and they overcame it with the UNIDROIT principles. And human beings always tend to be impressed by big numbers. So it's good to have now a big arbitration case and a big M&A case, merger and acquisition case by purchase of a company, which really where it has worked. And like this, I hope that will influence other normal transactions. So next. Sometimes it doesn't work. I already explained this. And next. So it's a wonderful tool for study, practice in academia. And I think with that, next, I'm finished. Thank you.
Thank you very much. I think we have time for one or two questions if anybody wants to ask the questions. If you don't feel comfortable asking them in English, please feel free to ask them in Spanish and I will gladly translate.
Thank you very much. Well, first of all, it was an outstanding presentation. And, well, the question is, as we know, arbitration and geopolitics are connected. And as we've seen, the WTO is like, a lot of experts are saying WTO is dying right now, right? Because of China is taking over this international organ, or maybe that the United States is leaving. The fact is, WTO is not sufficient, or it's not enough for the businessmen. Do you believe, from your perspective, that arbitration will replace completely the WTO? So we're talking about the, well, let's say about the inexistence of WTO and the emerging of international arbitration with these bilateral and regional trade agreements? Thank you.
That's looking into a crystal ball. The answer is not easy. Why? WTO is World Trade Order. Yeah? The follower from the General Agreement on Tariffs and Trade, the GATT. When I was a young lawyer in 1983 in Washington, there was Jackson on GATT, and a senior partner came to my room on a Friday afternoon and wanted an answer by Monday morning, brought me the book, which I'd never seen, and says, this is Jackson on GATT. With Jackson, in the WTO law, you can prove anything, you only have to put your mind to it. And so that's how it developed. But at the beginning, you have, of course, these investment things. Instead of protecting each other with guns, when investing, we had investment treaties. And in the investment treaties, you then ended up with arbitration. And for example, there's this exit arbitration in Washington, which is now functioning difficult because sometimes the arbitrators don't get the visas to get into Washington. So I simply don't know in what direction it's going to go. The trend until before Trump, everybody thought the trend is from arbitration back to international courts, which we're building up. And I'm with you, probably it now will bounce back towards arbitration.
Okay. See, last question, Jorge Huerta Goldman, please.
Thank you very much. A quick question and a very quick anecdote on the principles. A question, is there any database on utilization? Sorry, can you hear me now? Mm-hmm. Sorry. Is there any data set on the utilization of the UNIDROIT principles that can be accessible on compilation, on usage, and etc.? And then a very quick anecdote of two former students of ITESO, alma mater. We're preparing a hearing in Beijing for next month, and we're researching on Chinese law for agency. And the way we found the Chinese law was through the reflection of Article 225 of the UNIDROIT principles on the reasonably to believe that the agent has authority. So first we assess the facts in light of the UNIDROIT principles, and then we search the correspondent article in Chinese civil law. And it was a very useful tool to go from one step to another one. So it's an anecdote and a question. Thank you.
First, the anecdote, I love it, and it's the same thing which I did with the English guy in my arbitration. So once you have found the common ground, it is a very useful research tool. And the other part of your question was? Yeah, data, very good question, and I should have mentioned it. We have a website put up by Michael Bonnell, the chairman of the working group, unilex.info, UNILEX, unilex.info. And there you find cases both on the CSG and on the UNIDROIT principles, and you can look by articles, by courts, by issues. So if you have 225, you can see, is there any article on it? You have it.
Thank you. Well, I'm going to ask Dean Marcos del Rosario to come, please, to thank you, to give you a little diploma of recognition for the wonderful lecture and our appreciation for the lecture that you have given here today.
Professor Brodermann, thank you very much for your visit, and give you this certificate for your participation. Thanks a lot, Professor.